Welcome. I'm Bob Fitzpatrick, and it's my pleasure to talk with you today about settlement of employment disputes. Let me tell you first, if I may, a little bit about myself, just so you know my background is quite substantial in settlement of employment disputes. I've been practicing for some 45 years, almost all of it here in my hometown, Washington, D.C., and my practice over all of that time has been exclusively employment cases. During that time, I've settled countless thousands of employment disputes. Proud to say that very few of my clients are in litigation. Most of my clients are in one form or another of settlement negotiations, and most of my clients' cases end up being resolved without the need to go to litigation. I certainly know how to mud wrestle, if you will, with the best of them, and when we have to litigate, we litigate hard, but as I say, thankfully, we are able to settle most of them. I've written extensively about settlement of employment disputes. If you go online, you'll find what I call my tome, which I believe is something on the order of about 200 pages long, on practical tips for settlement of employment cases. And much of that is incorporated into a chapter in a book edited by, two-volume book edited by Richard Rosen on settlement of disputes. And there's an entire chapter in there authored by me on the settlement of employment cases. Let me at the outset, if I may, take us real quickly through some of the provisions that you should consider having in any severance, separation, settlement agreement of an employment dispute. And then I'm going to focus on some of the principal provisions that are of importance to the parties and drill down on some of the issues on those topics that I think are important for your practice. So let me just take us quickly through separation agreement. Should certainly have a statement of the last date of employment of the employee, the last date on the active payroll, and the last date that the company provided benefit eligibility. It's clear, you need to make it clear to the employee that accrual of benefits has ceased as of a date certain. There should be an acknowledgement by the employee that the employee has received all wages, all bonuses, vacation pay, other benefits, compensation, commissions due to the employee by virtue of his or her employment. You should have an acknowledgement that particularly wages, if you have a local statute applicable, that the wages have been paid on time. Many local statutes require that at termination the final paycheck be paid within a certain number of days. You want to be certain that your settlement agreement says that there's no issue about that and that there was compliance. There should be a general release of all claims, known, unknown, suspected, unsuspected, and I'll come back to releases as one of the excuse me, major issues that I think requires some extended discussion. There should be a statement that the employee is responsible for his or her own attorney's fees and costs. A statement that any of the benefits being conveyed, given to the employee in the settlement agreement may not be assigned. An acknowledgement by the employee that the employee understands the agreement fully, has had sufficient opportunity to review it. We'll discuss briefly the OWBPA, the Older Worker Benefit Protection Act, and the sometimes more often than not, 21-day review provision, sometimes a 45-day review provision. That the employee should be a statement that the employee has had an opportunity to review it with his or her counsel of choice, that the employee has been advised by management to review it with an attorney in the event that there is an ADEA, that is a federal age discrimination release, and you would want an ADA release in the agreement if the individual is over the age of 40, regardless of whether the person through their counsel has asserted an age claim. Once you seek an age release for someone over 40, you have to comply with the OWBPA requirements, which we'll discuss. And lastly, you want the employee to acknowledge that they have executed the agreement knowingly and voluntarily. You want an express denial by management of the validity of any of the employee's disputed claims, and a statement that nothing contained in the settlement agreement may be used or viewed as an admission of liability. We'll talk about taxes a bit later, but you want to have and want to be thinking, particularly if you're employee counsel from the outset, about tax issues and about what allocation of monies paid in the settlement you can legitimately allocate as between W-2 monies and 1099 money, and in some limited instances when you can allocate between taxable and non-taxable payments. Non-taxable, typically you're going to have a physical injury. Emotional distress is not a physical injury according to the IRS, and you're going to have a physical injury that is directly related to the, let's assume it's a discrimination case. You're going to have a physical injury that is a consequence of the discrimination, and it is rare that in these employment cases we have such a physical injury that would qualify for some or all of the money being non-taxable. The document should have an exclusion from the release. This is important to the employee, particularly of benefits in which the employee is vested by contract or law. You probably want to have in your agreement an acknowledgement regarding the employee's continuing duties, fiduciary duties subsequent to the termination of employment, most particularly with respect to trade secrets. If the employee has signed, particularly at the outset of their employment, a non-compete agreement, a non-solicitation agreement, an NDA, a non-disclosure agreement, a work-for-hire agreement, or any other contractual commitment, you want to review those, and the agreement, the ultimate settlement agreement, should provide, in most instances, those agreements remain in full force and effect. The employee's counsel should be aware of these agreements and may very well want to renegotiate the non-compete and the non-solicitation agreements. Some other terms to consider. Mutuality over the years has become a mantra for employee counsel wanting the release of all claims to be mutual, the confidentiality clause, which we'll discuss in some detail, to be mutual, and any non-disparagement clause also to be mutual, and we'll discuss the non-disparagement clause also in some detail. You may have monies being paid in lump sum. You may have monies being paid as continuation of salary and benefits rather than monies being paid in lump sum. And you need to address, of course, where monies are being paid over time, what happens in the event of the employee's demise, death, prior to the final payments being made. All too often, I've seen recently on many of my listservs where I communicate with other lawyers in the employment field, seeing, unfortunately, clients dying before claims have been fully paid off, and there are procedures that need to be followed rather quickly to assure that the estate steps in and gets the payments. Outplacement counseling is something to be considered at times. Quite frankly, when I started practicing, outplacement counseling was offered in almost every settlement. I think the vast majority of my clients, at least, found the outplacement service not to have sufficient value such that they really wanted to go to the mat to negotiate for it. And we moved from management offering it to our negotiating for more money and substitution for the outplacement. I think we've moved now, in most cases, outplacement simply isn't on the table anymore. I think most sophisticated executives know how to write their resume, know how to market themselves, know that much of it is word of mouth in terms of finding a new position, and they know how to market themselves in a 21st century way, most of which is online and, as I say, networking, word of mouth. So outplacement does not seem to be an item of any significance anymore as it used to be. Let me turn to the release of all claims and start with this. First of all, it should be what I will call a global release. Put another old-fashioned way, that is, the employee should be releasing all claims that he or she has that have accrued since the beginning of man up to the effective date of the agreement. The release should waive and release all suspected and unsuspected, known, unknown claims. Now, there are some claims that are not waivable. And for example, worker comp claims in many states, and you need to be familiar in many instances in terms of what state and local claims can be released. You need to be familiar with the applicable law of whatever jurisdiction you're in. Worker comp claims typically, for example, here in the District of Columbia, can't be released unless the release is approved by the Worker Comp Commission of the city. That's not a road you do. That's a road you do not want to go down if for any reason the length of time it would take to get the commission to approve. So you simply excise that out. Some releases, in order to get a valid release, you may have to follow certain procedures to shut down the claim over and above just getting the employee to sign off on a release. There's a lot of controversy, for example, about FLSA individual claims. Circuits are split on this issue. The Fifth Circuit having its body of case law, 4 or 5 other circuits having a distinctly different position with respect to the settlement of individual FLSA claims. In its simplest terms, and there's rarely anything under the FLSA that is simple, okay? So I am generalizing when I say in the Fifth Circuit, in some instances under the FLSA, you do not have to get court approval of an FLSA settlement. Outside the Fifth, in most jurisdictions, you have to get court approval of an FLSA individual settlement. And it is my experience and observation that the federal district courts have gotten fairly aggressive, I think is the way I'd describe it, about insisting that counsel come to them with FLSA settlements seeking approval, and that they demonstrate, following criteria that are set forth in a body of FLSA individual settlement cases, that they answer each of those criteria. And it's very, very frequently now that I am seeing federal district judges refusing to approve an individual FLSA settlement and sending the parties back to the table to renegotiate certain provisions, or to come back with more evidence to prove up that this is an appropriate case to settle. So you really, on these FLSA individual cases, and as all of you probably know, there are just thousands of these FLSA claims in the federal court system now nationwide. You need to be following your P's and Q's on settling those cases. In some instances in the release, some counsel feel comfortable in listing, this releases all claims arising out of your employment and the termination thereof, and then including, but not limited to, and then counsel begins to list scores of possible claims. And I've seen releases where literally there might be 2 pages of lists of possible claims. The obvious issue, I think, that some of us ask is, what about the one you forget to list, that is the one that the employee tries to come back and bite you with after the settlement? And is that a reason not to have these lists? There's a little bit of case law out there, and a little bit of it that is disturbingly not helpful on that issue. So I'd be careful. You certainly want to list every claim that the employee has asserted, and you want you certainly want to also list retaliation claims, because that is the piece de resistance, that is the soup du jour, if you will, in the area of employment law. There are countless retaliation cases in the court system, and rightly so, the employees bar views those as the cases, as among the cases that have the highest potential dollar value. So you certainly want to be absolutely certain that you have shut down the retaliation claims. Don't try to release future claims. We all know that simply is not normally permissible, and it's just an invitation to trouble in the future if there is some dispute about the validity of the agreement. Sometimes you may need 2 releases, and this comes up with some frequency where the employee is not fired, but is negotiating the employee's departure, and the employee, after the first, what I'm going to call the first settlement and the first release, remains employed in some sense, maybe just on the payroll and not coming to the office, but remains employed for some period of time with the employer, so that the employee may use continued employment as a platform from which to market themselves for another employment opportunity. And it's, from my experience as spending most of my time representing employees, that is oftentimes the ideal position to put my client in. That is, they can honestly represent to prospective employers that they have a job, that they are working for XYZ company, and they are looking for a better opportunity to move on, etc. He who has a job has a greater statistical possibility of getting another job. He who has a job paying X statistically has a greater chance of maintaining that X level of compensation, if indeed not even increasing that compensation. He who does not have a job has far less chance of getting a new job and getting a new job with the same comp package they used to have. And there are studies out there of older people who have been out in the market looking for new job opportunities for very prolonged periods of time. And I've seen one study where they hit a 6-month barrier, and if they're out 6 months or more, 20 years ago, the data showed after 6 months an uptick in getting hired. Now the data shows a downtick, that if you don't get a job within about that 6-month period of time, you may not get a job anytime soon. So being able to have that platform to market yourself is a terrific position for employees' counsel to negotiate for their client. That means that there will be eventually a termination date, and there will have been a time period between the first release and the termination date. And therefore your agreement should provide for 2 releases, one at the settlement, the second at the time of termination. As I said at the outset, oftentimes the employee counsel wants the release to be mutual. Sometimes there is push. In the old days, you just got blank looks from management. Your client wants a release, and the next question invariably would be born of suspicion, would be why? Gee, your client must have done something wrong that we don't know about. And so 10, 20 years ago, there was very substantial pushback about mutuality on releases. After a period of time, that receded, and it became pretty much state of the art that releases be mutual. Still, some employers will push back, wanting exceptions for fraud, embezzlement, theft of trade secrets, etc. As I said, if the employee is over the age of 40, then you're going to want an age discrimination release, and you're going to want to go to the OWBPA and adhere to its requirements, and you need to give a 21-day notice period to the employee to review and consider the proposed written severance agreement. That 21-day time period is waivable. Okay. Now, if there is, during the course of negotiations, a material change in what is being offered in the written proposed agreement, then the 21-day period may start to rerun. But keep in mind, it is waivable. And typically what happens is we negotiate the deal. Yes, there have been many, many changes from the original draft to the final draft. Yes, technically those changes were material. Yes, technically the employee could take 21 days if they wanted to continue to review it. But by that point in time, we have negotiated to a fairly well, and everybody is ready to waive the 21-day period and move on. And move on to what? A 7-day revocation period dictated by the OWBPA for age claims. And the 7-day revocation period is not waivable. And this is of critical importance to those uninitiated in OWBPA waivers. That means the effective date of at least the age release of the settlement is not until the passage of those 7 days. So, for example, if you're settling a flat-out age case and you're paying money to get rid of an age case, you don't pay that money until the 8th day. Otherwise, you are giving the employee money before there is an effective release, and you run the risk of the employee taking the money, revoking the agreement, and then you're in a tender back dispute. And I'm not going to go down the road of discussing the tender back cases. Suffice it to say, you simply don't ever want to make that mistake and put you in that mess. Now, there are circumstances, and we're not going to discuss it here today. It's a totally separate subject, maybe for a future LexVid, of there are instances under the OWBPA where you have to give 45 days for review of the proposed agreement rather than the 21-day period. And I'm going to call this, this is not technical, this is simplifying things. It's not technically 100% accurate following the language of the regs, and there are EEOC regs on complying with the OWBPA. The 45-day period typically kicks in when there is a layoff, a reduction in force of more than one individual, and in that instance, the employer has certain informational disclosure requirements to the employees whom they seek to get a release from. There's been a lot of regulatory and case law controversy about exactly what information has to be disclosed, how you define the decisional unit within the meaning of the regs, and so on. Suffice it to say, if you are doing a 45-day OWBPA, typically a mass layoff of some sort, you need to be sure that your counsel and your HR people are up to speed on complying with the EEOC regs and how the courts have interpreted the 45-day period and the informational requirements. Sometimes it's rare, but sometimes it happens that the employee actually does revoke. And the issue then arises as to what has been revoked. Let's assume we have a case where it was about race discrimination, but the person was over the age of 40, so you complied with the OWBPA and you have an age release in there. And the person revokes. Does the revocation only run to the age claim, and in all other respects the release remains a valid release, particularly as to the central claim you're concerned about, the race claim, and any downstream retaliation claim that might be coming? And the bottom line on this is, it's if you want to be belts and suspenders, it is how you draft the language of the revocation clause. And if you provide in the revocation clause that this portion of the consideration, the monies, was paid to the employee to obtain the age release, and if there be a revocation, the revocation only applies to that claim and that claim alone. Quite frankly, I rarely see counsel gild that lily, if you will, but there have been a few troubling cases out there about what does the revocation revoke. All right, I think that's all we needed to talk about in terms of releases, except to say that there are certainly certain claims that need to be handled, if you will, gingerly. FLSA claims, FMLA claims, there's been some controversy about how they should be released. NLRB claims, and they are on the uptick, and many employee lawyers now filing charges on behalf of employees who are not represented by any union with the NLRB taking jurisdiction over these. Many cases having to do with employee handbooks that have non-cooperation confidentiality clauses that the NLRB social media clauses that the NLRB finds to be violations of Section 7 of the NLRA. How you release an NLRA claim is a separate matter, and as I say, should be on your list if there is such a claim to do it properly. Worker comp, I referred to, you need to know your local jurisdiction law, and then there are many state and local laws having to do with how to release state and local wage claims. California has a special statute on settlements. New York, West Virginia, for example, have local statutory provisions on releases of wage claims. Finally, on kind of this list of the ones to be especially careful of is the False Claims Act. While the False Claims Act might not be considered to be an employment case, certainly many of those cases have arisen out of an employee who is being terminated or being disciplined, going to counsel, and counsel during the course of discussions with that individual discovering that there may be a False Claims Act claim there. The issue arises, and I'm just going to note this and not discuss it in any depth. If there is a global release of all claims, and that global release, let's assume, does not specifically refer to the False Claims Act, does that release prevent the employee from becoming a relator in a False Claims Act action in federal district court, which is, you probably know, is a sealed proceeding? Or let's even assume, unbeknownst to the employer, and this happens, there is already, at the time of settlement, a pending False Claims Act action in federal district court that is sealed, and therefore, in many instances, the employer is totally unaware that a lawsuit has been filed against it. What is the effect of that global release on the ability of the relator and the government to move forward on the False Claims Act front? Suffice it to say, the courts have tried to address this difficult issue, the Fourth Circuit being one of them, and maybe that is a subject for further discussion in another LexVid. All right, another major provision that needs to be addressed in any employment settlement agreement is the underlying administrative complaint or complaints that the employee has filed. And there is a plethora of federal, state, and local agencies where the employee may have filed, and you may, as the employer, not be aware of this. You may not be aware that the complaint has been filed. You may not have been served by the agency. But there may be a complaint pending at EEOC. There may be, as I alluded a minute ago, something at the NLRB, something at the U.S. Department of Labor, at OSHA. There may be a FEMLA at DOL. There may be an FLSA. There may be a whistleblower. There could be a Service Contract Act complaint, and on and on and on. At the state and local level, here, for example, where most of my practice is, D.C., Maryland, and Virginia, we have a D.C. Office of Human Rights, a Montgomery County Office of Human Rights, Prince George's County Office of Human Rights. Across the river to Northern Virginia, every county and city, it seems, has a human rights deferral agency from EEOC. There are wage and hour offices. DC has a wage and hour office that enforces our DC wage theft statute. And of course there is the Worker Comp Commission. So the employer, of course, wants to wipe the slate clean and shut down all of the administrative complaints and have them withdrawn. Wants the federal, state, and local agencies to approve withdrawal of the complaint. The employee, as a practical matter, does not want the effective date of the agreement to be deferred, and that is payday when the money is paid, to be deferred, to be dependent on when the federal, state, or local agency finally maybe approves withdrawal of the settlement. Nearly 100% of the administrative complaints are eventually approved for withdrawal by the agency, but like so many things with government, it doesn't happen quickly. And therefore, the Employees Council negotiates for, I will submit jointly with you, management, a request to withdraw the complaint, and we will honor any request from the agency for information about the terms of settlement in furtherance of an effort to get them to withdraw. In my experience with EEOC, all EEOC in 99.9% of cases, all it wants is how much money is being paid by the employer to the employee and Employees Council, and the reason for that is EEOC then takes credit for the settlement, even though it may have done absolutely nothing in furtherance of the settlement, but they then report on their books that they were able to withdraw a case and got X thousands of dollars for the charging party, and somehow that makes them look good statistically in reports and records that they submit. Some administrative charges, as I think I've indicated repeatedly, can't be so simply disposed of. Worker comp claims, for example, FLSA, etc., as I've mentioned. If there is a collective action, a term of art under the FLSA, or there is a class action, there are very special settlement procedures that need to be followed. We will not discuss those here today. Suffice it to say, maybe that's a good subject also for another LexVid. How do you settle a collective class FLSA action or a class action for some form of discrimination? Okay, let's move to the ubiquitous confidentiality clause. This, back in the day, was a no-brainer. The employer does not want to have the terms of the deal disclosed, particularly does not want co-workers to know the terms of the deal out of a legitimate concern, it seems to me, that leaks of how many dollars were paid to so-and-so will encourage others to assert claims, and will only lead to further lawyers knocking on their door to try to obtain similar settlements. There certainly is a feeling out there on the part of some managements that once you step on the slippery slope and settle big with the first employee, you are on, as I said, a slippery slope, and others are going to line up seeking similar money. So employers want a confidentiality clause, but oddly, in my judgment, it is not approached anywhere near correctly. The confidentiality clause ends up in the final document, and in almost all cases there is a confidentiality clause. But we've been negotiating for weeks, months, maybe this has been in court and has been going on forever. And there have been intermittent, there have been extensive, what have you, negotiations, and there hasn't been any requirement that people keep their mouths shut and not share with others what's being discussed. So the genie is out of the bottle already. And now at the end, there is a confidentiality agreement when potentially many people, friends, co-workers, associates of the employee, and other lawyers with whom employee's lawyer may have been discussing how to value the case and what others think of offers that have been made by management and so on. All of that is already out in the chatter world, and the world we live in today is an online world. So the genie is big time out of the bottle, and you can't get it back in. And I have recommended, it doesn't happen. I don't understand why it doesn't happen, but I have recommended that the posture of management ought to be at the outset, right? First phone call from the employee's lawyer ought to be met with, I'm glad you called, happy to talk, happy to see if we can work this out, but first we need to enter into a confidentiality agreement that provides that our discussions and any offers and counter-offers that are made are strictly confidential, and they may only be disclosed to the lawyers in your firm, to your by your client, the employee in question, to spouse, financial advisor, tax advisor. That's pretty much it. That doesn't happen. That happens at the back end when I think in most instances it's too late. Now, as employees counsel, if you are in a typical situation where the confidentiality clause is put in place at the back end in the final agreement, you want to be very careful to watch the language, that the language of the confidentiality clause doesn't look backwards, only applies to disclosures, statements, comments made by the employee or by you going forward into the future. Don't allow a language to be snuck into the agreement that says you have not disclosed in the past the terms of this agreement, because they have been disclosed. All right, now having said all that, in my experience, confidentiality clauses seem to be violated, I don't know if I'd say with impunity, but they certainly are frequently violated. I have had countless conversations, and I discourage them for a lot of reasons. I don't like collateral damage. I don't want to be a party to a encouraging or somehow complicit in a violation of an otherwise valid agreement. But I've had countless conversations with employee clients where they say they have had conversations with others who have settled with the company, and those others have told them on the QT how much money they got in their settlement. So I think that takes me, with my management hat on, if you will, to I want some pretty significant penalties I want to shut down put the confidentiality provisions in place at the front end, as I've recommended. And I want to have pretty significant penalties for a violation of the confidentiality provision, including a clawback and maybe a liquidated damage provision. Liquidated damage provisions are tough to get in negotiations with good employee counsel, because my response invariably when management asks for a liquidated damage clause, I just say, fine, let's make it mutual. End of discussion. Let me just button up the confidentiality discussion. Almost 100% of the time, the confidentiality clause in my practice ends up being only in the final agreement, and there are certain exemptions of people who are not covered by the confidentiality clause. For management, it is typically those people who have a, quote, need to know, would sometimes, not all the time, but sometimes where it is an issue of concern, particularly to my employee client, maybe where there's been a lot of hostility, and maybe the deal isn't a great deal, and maybe people at management would like to mock the fact that he or she only got some small amount of money in a settlement. So the employee actually, in those instances, may have a stronger incentive to have an enforceable confidentiality clause, and wants to go some steps beyond just those who have a need to know and try to specify some people. But typically for the exemptions from the employee's obligation to maintain confidentiality, the exceptions would be to any regulatory agency, EEOC, etc., particularly during the withdrawal process, tax preparers, tax advisors, financial advisors, obviously your counsel, your spouse, sometimes fiance. I've even had significant other with that person being identified, domestic partner, etc. Management then sometimes wants, and it takes a variety of shapes, sometimes wants the employee is obliged to inform any exempted person to whom a disclosure is being made that this is confidential may not be further disclosed, etc. Sometimes the employer side wants the person to whom the disclosure is being made to sign a document acknowledging that they've been advised that it's confidential and that they understand they are not to make a further disclosure. Finally, on confidentiality, at the end of the day, typically both parties, but particularly the employee, wants to be able to answer inquiries from friends, colleagues, whatever, who know that there was a controversy that occurred at termination, at the individual's departure from the company, and knows that he or she is going to be asked, well, how'd all that work out? What happened? Hey, what happened with your case against the company? And the answer that oftentimes is negotiated is the matter was resolved to my satisfaction, and maybe adding not at liberty to further discuss. All right, let's move to what has become a major issue in the negotiation of employment settlement agreements, and that is the return of company property. In the old days, it was just return the office key, then maybe we moved to return the office key and a swipe card. Now we have moved to keys, cards, and documents, hard copy and soft copy, that is digitized documents and digital devices. Most employees have a company-issued laptop, a company-issued smartphone, cell phone, and this has become a significant issue in far too many negotiations. 5 years ago, I'm going to say, I sat at my desk one day and I looked at one of the associates and I said, we're spending about 20% of our time on computers, and how do we get what our clients have on their digital devices deleted and or returned to the company without the company getting access to the other things that are on the digital device, personal information, because nobody walks around with 2 laptops. Nobody, or few, some do actually, but most people only walk around with 1 cell phone. And so the devices have a mixture of personal and company information. The personal information sometimes being highly personal. Medical, tax, personal financial data, romantic stuff to spouse or others, etc. So the issue becomes, how do you return to the company what is its, or get the company to agree that your client has truly deleted what was the company's and was on their devices, and has only retained on the devices what is personal to them. This is assuming that as a part of the negotiations, the employee is going to be gifted, it's a taxable transaction, by the way, the devices. If the devices are physically going to be returned, then you got to do it the other way around. Here, the devices now have all of your company stuff, but all of the personal stuff has been removed and deleted. And when these issues first arose, and it seems like 5 years ago, an extraordinary amount of time was dissipated, wasted in counsel trying to resolve those disputes. I think it was largely because it was new to all of us, and we were trying to find a way through these problems, and all of us as adversaries being a little bit paranoid, being belt and suspenders types, went way over lawyering these issues. I think most of us have now moved to a better place where we can simply agree upon a protocol. One of the things that we do, for example, is the client removes the data, sometimes in the presence of an associate in my firm, and we certify it was done, and that's the end of it. Nobody is going to try to run up the bills and make the protocol any more difficult than that. Having said all that, it increasingly is important that employers' counsel, have had beaten into them for years and years now, their preservation obligations of evidence, particularly of e-discovery, of digitized information. Employee counsel needs to counsel their clients at the front end in that first, second phone call that the employee has preservation obligations and that the employee ought not to be deleting or making access more difficult than it is to access the digitized information relating to the company. Don't forget, of course, with the focus being so much on e-discovery and digital information and data, don't forget a hard copy of documents. I've had clients who tell me, gee, I just went out in the garage and found 10 boxes of company documents. Trust me, the company really didn't want them back, but we sent them back, and it saved him some room in his garage, I guess. Then I think the final point on this is the company says in broad terms, return everything that is a company document. And there, in almost all cases, are some documents that the employee wants to keep. Documents from the personnel file, documents that reflect promotions, compliments, letters of appreciation, awards, certificates, so on. I've never had an employer say no, but you want to spec that out and put it at least in a side letter. Have your client focus early on what does the employee want to keep. All right, I'm moving now to a red hot topic. No rehire, no reapply for employment clauses. And back in the old days, these were a snooze. Almost every agreement had a no rehire clause, and it was not an issue. It is now a huge issue with both the employees bar and with the EEOC, the NLRB, the SEC, etc. So why does management ask for these clauses? Well, the answer to that's pretty simple. The employer is, I think, legitimately concerned that the employee will reapply for employment will, we all know, not get hired, and then will turn around and file yet another complaint with EEOC saying, I've been retaliated against. The only reason I didn't get hired was because I had been involved in the earlier discrimination, what have you, case against the company. So management's simple solution to that problem is, okay, you cannot ever reapply for employment with us, and we have no obligation to rehire you, and in essence we are absolved of any claim if you do reapply and we do not hire you. These clauses have become very controversial. The Ninth Circuit, under California state law, under its Business and Professions Code, section 1660, has found such clauses in essence to be a prohibited non-compete provision. In a 2-to-1, there was a significant dissent in the case. The circuit suggested that such clauses would be a violation of 1660. Despite the EEOC's position that it will challenge and believes these clauses to be bad public policy, there is a long string cite of cases approving such clauses. And there is also a federal sector decision that is a claim against a federal agency under Section 717 of Title VII. And those cases sometimes end up in an EEOC office called OFO. I guess that's the Office of Field Operations, or Federal Operations, forgive me. And OFO reviews and writes appellate decisions from agency federal sector decisions, and there is an EEOC decision approving a no rehire clause in a federal sector case, a decision that obviously is totally inconsistent with the Commission's position that no rehire clauses are inappropriate, illegal violations of public policy. All right, let me take us through a few other topics quickly. How is the termination to be characterized? And let's assume the individual has been fired. Trying to honestly market yourself, and when asked why did you leave your last employer, and having to answer saying I was fired, terminated involuntarily, is not a great place to be in terms of marketing yourself for future employment. And lying to a future employer is certainly fraught with risk. If that lie is discovered in the future, it might be the basis for discharge, and certainly is not going to make the employer real happy to discover that you, in essence, frauded them when you applied for work. So one of the tasks of employee counsel is to try to renegotiate why the departure of the individual from employment. Sometimes it's the best you can get is it was a resignation. That, it seems to me, there's a lot of I mean, that's better than being fired, but there's a lot of downside with a resignation. Clearly, if I'm sitting on the other side of the desk and somebody comes and applies for work to me and they tell me I was working for so-and-so and I was making oodles of money doing whatever, and I quit, I simply don't believe them. Who quits a well-paying job to look for a job? You look for a job while you're working, and move from one job to another. So I'm typically looking to renegotiate the termination to be something like a RIF, a reduction in force, and try to structure the appearance that that indeed is what it was. Now, are there questions regarding honesty when one applies elsewhere and is asked, why did you leave your last job? And now the negotiated statement will be, well, it was a reduction in force, and that may fly. Eyebrows may not be raised, and the person has enhanced their employability, but have they been deceitful? Have they lied? I would like to think, as employees counsel, that they haven't, because we have an agreement that that is why they left, not that they were fired. Sometimes I will get the individual return to, we agree upon an amount of money, and rather than lump sum all of it, we will have some of it as returned to the payroll at your same level of compensation and benefits. You probably don't, the employee probably doesn't return to the office, but is on the payroll, is held out as an employee of the company, and can use that as to me, the ideal platform to market yourself for other employment. We just made an executive decision, if you will, that we are at the approximately 1 hour and 20-minute mark, and as you can see, I have quite a bit else to say, and we're going to do a part 2 and pick up this discussion. The part 2 will probably be at least another hour or more, discussing settlement of employment cases. So we're going to leave it there for today. I hope you found this helpful. Please do not hesitate, if you view this and have comments, reactions, questions, whatever, please reach out and contact me. I live on email, fitzpatrick.law@verizon.net, fitzpatrick.law@verizon.net. I very much welcome your comments. I'm just one guy out there working in the vineyards, settling employment cases, and I'm confident many of you watching this video have some very interesting and helpful observations and ideas and experiences on settling employment cases, and I hope you'd share them with me. Thanks for attending, and I hope you will attend part 2. Thanks again. Bye-bye.